Court proceedings began with the former head of state's legal representatives arguing that the High Court does have jurisdiction to issue an interdict to stay the execution of Zuma's arrest.
The Commission of Inquiry and its chairperson, the Acting Chief Justice or Deputy Chief Justice Zondo, they have elected to oppose the application for the execution of what I call the arrest warrant. Then we have, as if that is not enough, the Helen Suzman Foundation, which really has been cited here simply because it was an amicus in the main proceedings. It's a party that has no business really in this proceedings. And we will show your Lordship that neither does the Commission or the Acting Chief Justice.
When asked why the matter was not brought to the Constitutional Court instead, Mpofu told the court that his client could not fund the litigation, a response that the Commission and Deputy Chief Justice's legal team opposed.
We invited expressly the applicant to approach the Constitutional Court. You asked him the question also today, and what you have heard is that it was a choice they made. Mr. Zuma simply did not want to be litigating in two forums. So he deliberately chose not to go to the Constitutional Court and to put his eggs in the High Court basket.
Concerning the issue of jurisdiction, advocates Ngcukaitobi and Max du Plessis argued that the High Court could not interfere in a Constitutional Court matter. On this basis, they moved for dismissal.
The first misconception arises, my Lord, from Mr. Zuma's legal team trying to recast him as a victim of the Constitutional Court. And we've heard repeated references by Mr. Mpofu, our learned friend, to Mr. Zuma's dignity and his liberty, and the need for habeas corpus, and so on, Lord. But Mr. Zuma is no victim. This case is about past and ongoing defiance of the rule of law.
In his responding argument, Mpofu reiterated that the High Court had the authority and jurisdiction to hear an application challenging the Con Court's decision,